I first and foremost want to express my gratitude to Governor Newsom and the Director of the California Department of Housing and Community Development, Gustavo Velasquez, for their ongoing partnership and collaboration. We have teamed up to take on our housing crisis throughout the state of California, and I've been very grateful for that partnership and the ability to work together, share resources, insight, and other intelligence to help make a difference, and we've made a great difference so far when it comes to tackling homelessness and housing affordability. We are here today in that spirit to announce a lawsuit against the city of Norwalk. We filed the lawsuit today in Los Angeles Superior Court. We brought multiple causes of action because Norwalk has violated multiple components of the housing law in California. We have sued the city of Norwalk for knowingly violating state housing laws, for infringing on the rights of vulnerable residents, and for choosing to stifle affordable housing projects. Let me state the obvious. California is facing an existential housing crisis. It's one we should all be acting in unison to solve. I tell our local jurisdictions all the time, none of you need to do everything, but all of you need to do something to build the housing you are required to build by law. Act in good faith, follow the law, do your part, and together, collectively, in aggregate, we will make a difference in building more housing throughout the state of California, which is why it is so disappointing we've had to resort to this action. Let me be clear, we'd prefer not to be here with the lawsuit in court. We would prefer that Norwalk simply follow the law, but they have chosen. It is their choice. They've decided to willingly, intentionally, and deliberately violate the law. So our message is clear. Our message is consistent. If local governments attempt to skirt state housing laws, if they refuse to do the bare minimum to address the dire lack of affordable and accessible housing in California, we will hold them accountable. And we are holding Norwalk accountable today. This should come as no surprise to them. They saw this coming, and they chose this path. So rather than spending their time and resources on solutions, Norwalk, in August, unanimously passed an urgency zoning ordinance imposing a 45-day ban on new supportive housing. They put a stop to building homes that we need most, supportive housing for lower-income folks. They halted plans for new emergency shelters and transitional housing that would get Californians indoors and off the streets, and attainable single-room occupancy housing. And they did that by passing an urgency zoning ordinance, which requires written legislative findings that there's an imminent threat to public health, safety, or welfare that demands immediate action. In other words, the city claims that housing the unhoused is an imminent threat to public health, safety, and welfare. Not the threat to homeless folks who have to live on the streets and in public, but that housing them, the solution to homelessness, is the threat to public health, safety, and welfare. That was cynical, that was wrong, and that was illegal. It was also a clear attempt to circumvent our state housing laws. Banning housing for the most in need of housing doesn't just defy common sense, it violates the law. Today's lawsuit should come as no surprise to the city. Both of us standing up here, the director and I, sent emphatic warnings to the city of Norwalk, telling them that we might end up right here if they don't comply with the law, several times. In September, I warned the city of Norwalk not to go through with its plan to ban new emergency shelters, transitional housing, and supportive housing. HCD even sent them a notice of violation in September and met with them just last Friday. Apparently, these warnings were not convincing, nor were the other actions I've taken to hold other local governments skirting our laws accountable, like our ongoing victories against Huntington Beach, Elk Grove, and other cities. Instead, the city of Norwalk decided to extend their ban for an additional 10 months and 15 days. And once again, this decision came without the required legislative findings or deliberation based on an unfounded claim that housing for the people who need it most is a threat to public health, safety, and welfare, that providing shelter, a roof over a Californian's head, a place where a Californian and their family can put their heads down at night safely and securely, that is a threat somehow to public health, safety, and welfare. The thing is, that is illegal. No one gets to pick and choose the laws they want to follow. If you wish, in our incredible system of government, you can advocate against legislation when it's proposed. You can call, email, and tweet at the governor not to sign a bill. You can challenge a law in court after it passes. But you can't ignore a law because it doesn't suit you, your plans, your ideas of what California should be. You must follow the law, all laws, all the time, especially when you have the power and the legal obligation to approve or disapprove new housing that Californians are desperate for, yearning for, that they need. And it's our duty as government to provide. The law is the law. It applies to everyone. It applies to the city of Norwalk. And our state housing laws are clear as day, as is Norwalk's willful refusal to follow them. That's why we're in court challenging the city's unlawful actions and asking the court to suspend its ban while our lawsuit continues, to suspend Norwalk's ban. The housing crisis isn't going to be solved overnight, but rest assured at DOJ we're doing our part, and we will continue. We're committed to using all the tools at our disposal to advance housing access, affordability, and equity in California. And we're turning the corner. To date, the work of my office's Housing Justice team in concert with HCD has led cities across California to plan for 22,000 new units of housing. That is progress. All cities, including Norwalk, should be part of that progress, not deliberately being part of the problem. And we've changed the conversation in many city council chambers and planning departments throughout California so that more people than ever are asking, how can our community do its part for housing justice, to build more housing for more Californians? And to the local governments that aren't concerned with that question, consider today a reminder. California's nation-leading housing laws are not optional. They are not recommendations. They are not suggestions. They are the law, and they must be followed. We will hold anyone attempting to skirt them accountable. That is not a threat. That is a promise we're keeping here with the city of Norwalk. My office will continue to use the full force of the law to ensure Californians have a place to call home. And can I just add, it's actually beneficial to work with the California Department of Justice rather than against us. Beneficial to build affordable housing for hardworking families, to create opportunities for young people and seniors to live near family and friends, and for working people to be near jobs and opportunity. It's the only way forward. So thank you. I'll be back to answer questions, but now I'd like to pass it off to my and our office's great partner in this important work, HCD Director Gustavo Velasquez.
Thank you. Good morning. Buenos dias. On behalf of Governor Gavin Newsom, Secretary Tamika Moss, everyone in the Newsom administration, I want to start by thanking the Attorney General, Rob Bonta, for his unwavering commitment and dedication to ensuring that by all legal means possible, every Californian has access to safe, dignified shelter and access to supportive, permanent housing solutions, which is what the city of Norwalk has decided to ignore. About a week ago, I was standing with Governor Newsom, not far away from here in Skid Row, Mayor Karen Bass, multiple county elected leaders, and also multiple city elected leaders in the region of Los Angeles, announcing more than $370 million in HAP funding, the Housing and Homelessness Assistance and Prevention Grant Program, which is flexible funding with a lot of accountability measures, but flexible funding for the region of LA as a region to tackle what the governor has called the crisis of our time, homelessness, and especially unsheltered homelessness. The city of Norwalk was absent at the event, but the city of Norwalk was also absent in their moral and legal obligation to work with the rest of the cities, the county, the entire region of LA in addressing this issue. The week before last week, the governor also announced more than $100 million in encampment resolution grants for the city and the county of LA. So it's only been less than a month that this administration has announced hundreds of millions of dollars to address the problem of homelessness. And these investments are being made because there is a clear understanding that Los Angeles and the greater Los Angeles region is the epicenter of this problem in the country. And we have to do everything possible to solve it. So words cannot fully express our frustration and disappointment in bringing this suit forward. Thank you, Attorney General, for acting quickly on this. Cities have a moral obligation to support their residents' fundamental human rights and dignity, especially those in need. By choosing to ban shelters and to ban permanent housing solutions, Norwalk is neglecting these responsibilities. As the Attorney General said, back on August 6th, there was this temporary ban, moratorium, and the state acted swiftly. Multiple meetings through the Housing Accountability Unit, which was created at HCD by the governor back in 2021. And in partnership with the AG, we worked together to make sure that the city would reverse course. In September, HCD and the governor informed Norwalk that its actions conflicted with their housing goals and rescinded state approval of their local housing plan or housing element. It's a lot of administrative repercussions in rescinding that local housing plan. But rather, after that action, rather than reversing course, the city further entrenched itself and left the state with no alternative outside legal remedies. And let me just say a point that the Attorney General said clearly. This reason of discussing for some reason shelter capacity a threat to safety and public health is utterly ridiculous. If you talk to any expert having studied this problem of homelessness, scholars, researchers studying this problem and its solution for decades and decades, they can tell you that promoting, establishing greater shelter capacity, temporary, interim, and permanent housing is the way to solve the issue of homelessness. And it is the way to promote the public health and safety of the people encountering homelessness and everyone else. So every city and county has a role in delivering on the state's ambition housing goals, especially housing that takes care of people experiencing the terrible cycle of homelessness. It is too important for a jurisdiction to fail to act with the urgency and willingness needed to address this. What Norwood has done does not solve homelessness. It hides it. It pushes the issue into alleyways, overcrowded rooms and tents, leaving people nowhere to go. Homelessness doesn't go away when we ignore it. And another argument that we've heard is that by increasing shelter capacity and permanent housing in the city of Norwood, somehow it invites people from surrounding jurisdictions into the city of Norwood. Again, there are more than 200 people that live on shelter in the city of Norwood, according to the latest point-in-time count. But Norwood is surrounded by many other jurisdictions, and the city the residents of Norwood go through this boundary, inadvertently. It is an invisible and unnoticeable boundary. But more importantly, Norwood has to work together with other cities in the region, with the county, to solve this problem, to be on board with what the region of LA is doing, which is working comprehensively, regionally, and for that they have been awarded $370 million as of last week. So in closing, I just want to say, from Anaheim over transitional housing for women experiencing homelessness to housing element compliance issues in Huntington Beach and Elk Grove and more, this administration has worked diligently in cooperation with the Attorney General Office to take swift legal action. Governor is committed to continue working with Mr. Bonta. Many jurisdictions, let me be clear, are doing the right thing, and we applaud them. They are following their laws, submitting their plans, taking actionable steps to reduce barriers to affordable housing development, and affirmatively further inclusive housing. However, for those not meeting the moment, this administration will act swiftly to deliver a resolution and ensure compliance with California's housing law. Thank you, Mr. Bonta, for this action.
I want to emphasize one of the points the director just made around the vast majority of cities and local jurisdictions throughout the state doing their part. Thank you to all those cities who are participating in a solution, contributing to creating more housing and more affordable housing throughout the state. We need more of that. Norwalk and Huntington Beach and Elk Grove have been the outliers, and they need to come in compliance with the law. Two quick notes. In the unlawful urgency ordinances that the city of Norwalk passed, they very offensively and insultingly, I'll say, likened compassionate, humane, dignified housing and shelter to threats that they, similar to payday lenders and liquor stores. They likened them as being the same, that were worthy of and needing of an emergency ordinance to protect the immediate threat to the health, safety, and welfare of the city of Norwalk. I'll also say this, that in their own housing element, the city of Norwalk's housing element that was certified, where they needed to plan for the building of about 5,000 units in their city of almost 100,000 over the next 5 years. They planned and put in their certified housing element that they would build single-room occupancy housing, transitional housing, supportive housing, emergency shelters. The exact things that the urgency ordinance prohibits them from building. So it is the height of hypocrisy. And they have managed to not just be offensive and insulting, hypocritical, but most importantly, and this is where this all boils down to be unlawful. They're breaking the law. We're taking them to court to hold them accountable and get them in compliance. With that, I'm happy to answer any questions you might have. Hi. There's a number of projects that sort of contextualize where we are. There was a past project, Room Key project during COVID, so many years ago. There are some currently pending planned projects right now that are grandfathered in and are not affected by the urgency ordinance. And then there was a major investment by the county that was being considered, and the county has decided to move away from that project. But they brought their own ban earlier this year in that context. It wasn't a specific project. And then they extended it after hearing from us that their first ban was unlawful. So I know that they have some grievances about past projects, but to my knowledge, there wasn't anything specific about this. They were ready to take their ball and go home and say, we're not going to participate in any more affordable housing when it comes to transitional and supportive housing, emergency shelters, and single-room occupancy. And it's just blatantly unlawful. Hi. I mean, to the extent that they have a housing element that's been decertified, to the extent that that now requires that the builder's remedy kicks in, so that certain affordable housing projects, should a builder want to build them in Norwalk, cannot be denied by the city, and to the extent that they are now ineligible for certain types of affordable housing funding, they are already experiencing the consequences of their actions. We've now asked a court to strike down their unlawful urgency ordinances and set them aside and determine and declare them null and void. That will take some time to go through the process. We are very confident in our position. It's just a matter of time before we believe that order will be set forth by a court. And meanwhile, starting on January 1st, there could be some significant penalties that kick in under California state law if the city of Norwalk has not complied by then. And of course, that's all within the official court procedure. At any time, should it feel moved to comply with California law, the city of Norwalk can set aside their urgency ordinances and move forward in a compliant fashion with the law of California. More than days, since we're just filing today. Probably more in the months, but we could get a decision, a critical decision before the end of the year. And should there be a attempt to build a project in the city of Norwalk in the coming weeks and months that is stymied and stifled by these ordinances, that could create that could tee up a decision by the court to immediately strike down their ordinances and allow the project to go forward. That's sort of situational and dependent on a specific project. So we are probably still, months away from some critical decisions, but could get something significant before the end of the year. I'm not particularly aware. We are communicating with county officials. We think it's appropriate to be in discussion with the different entities that are involved with affordable housing projects in Norwalk. The state obviously has been one. The county has been one in the past. I don't see how they would not be supportive of us enforcing the law. It's the law of our state. It needs to be followed. LA County is in a housing crisis. They need all of their cities to participate in a solution. The city of Norwalk has raised its hand and removed itself from that group of participating local jurisdictions, and it's wrong, it's unlawful. So don't want to put words in anyone's mouth, but I don't see how they would not be supportive of an action that enforces the law of the state of California when it comes to addressing the housing crisis in our state. Any other questions? Thank you for coming. Appreciate your time.